Hi, this is a case study for courtroom drama. My name is Tara Porter and I have been assigned to the following case, which is case number 1 has been chosen for the review. The case that's presented before us is that a hospital implements new minimum necessary policies for telephone messages. The general hospital issue consists of minimum necessary confidential communications. The plaintiff in this case is Jacob Jones, who is also the patient. And the defendant in this case is St. Ashford Hospital on behalf of their employee, whose name is Beverly. Beverly, who's an employee at St. Ashford Hospital, did not observe the minimum necessary requirements when she left a telephone message with the daughter of a Jacob Jones, who is a patient that, and this message detailed both her medical condition and treatment plan. And OCR, which stands for Office for Civil Rights Investigation, also indicated that the confidential communications requirements were not followed, as Beverly left the message at the Jacobs home telephone number despite his instructions to contact her through her work number. After close examination of both the plaintiff and the defendant's pleas and investigating the situation, I have come to the decision as a juror that the defendant, Beverly, is guilty of compromising a patient's privacy. However, I also believe that St. Ashford may be at fault as well. The hospital should have taken more time to go over privacy policies with employees to avoid these legal issues. Therefore, if they trained their employees better, they would have been more aware of checking the phone stipulations in order to avoid leaving a message at the wrong phone number. The Health Insurance Portability and Accountability Act of 1996, which is also known as the HIPAA Privacy Act, is best known for protecting the privacy and security of patients' medical records. It provides certain patient rights over the access, use, and distribution of personally identifiable health information, as well as criteria for information disclosures and security requirements that healthcare providers, insurance plans, and clearinghouses must follow. This Privacy Act has been breached by St. Ashford Hospital and employee Beverly, who clearly left a phone message mentioning the patient's private information on an answering machine that permission was not granted to use as a messaging service. According to the U.S. Department of Health and Human Services, the penalties for privacy violations can be very severe, ranging from imprisonment to upwards of $50,000 in fines. However, I think it was an honest mistake and therefore think OCR should reduce the penalty and give the minimum fine or even a warning to St. Ashford Hospital, to which they can rely to not only Beverly but their employees. And additionally, I think Beverly should undergo a training course to better acquaint her with the privacy stipulations to avoid future mistakes. I think these mistakes can be easily made if the employees are not acquainted with the system. There should be requirements that pop up when relaying messages that tell them whether or not this message can be relayed to this answering machine, or in this case, there was details not to leave a message on this machine and to call the daughter on her work phone number. And these requirements were not met, therefore the patient's privacy was breached. And I mean, technically the patient could sue the hospital if they wanted to, because now their information was put on a machine where anybody could hear it, and it may be things that they may not want to be heard. So it's a very serious situation, and I think that the hospital should better acquaint their employees with the rules and regulations of the Privacy Act. This way, reducing or even getting rid of altogether any issues that have to do with breaching the privacy of their patients in future references. Thank you. Bye.